Hi everyone, and welcome
Everyone.
to another
Very
Q&A
excited.
for my very first live Q&A without having some technical issues here. Hi everyone, welcome to this other live Q&A. My name is Cédric Marin. I'm an immigration lawyer at Holt Immigration Law, and today we're going to be focusing on express entry. So everything related to express entry. We are Tuesday, August 2nd, and it is widely expected that tomorrow on August 3rd, there's going to be another express entry draw. So the goal of the podcast today is going to be to make sure that your profile is up to date, to talk about language scores, to answer all your questions about express entry. And on my live Q&As, we do them right now at a really weird time if you're in Canada. So right now it is 4:15 a.m. in Toronto. However, it is 9:15 a.m. in London, UK. So if you're abroad, I am teleworking right now. I actually telework a lot of the time. You can book a consultation with me and speak to me during the daytime. If you're abroad, and if you're in Canada, I'm actually available in the morning. So if you like to wake up early and speak to a lawyer and tackle the hardest problems of your day, I am here to help you. So, as we talked about last time, we're actually going to be taking questions from the previous um, live Q&A. So comments, if you're not able to join us, you can leave a comment and I'll do my best to look at your question in our next video. So let's switch right to it and let's look at comments from my previous video. So we're not talking about the live Q&A, but we're actually talking about comments from people who are not able to join us. So let's switch over here, and here are questions that people have left me from the previous Q&A that I prepared, which is fantastic. And we also have other questions from other videos that we're also going to be tackling. So in particular, uh, there was a question that I wanted to highlight here that was about language. Let's just try to find it here. Sorry, I had a really interesting question that I thought could really help. Could really help a lot of individuals. So I just want to try to find it again. I'm trying to see where I found it. Sorry, just give me one moment. Where is it? And anyways, can't find the question, but let's flip right to it. The question was asking about language scores, and I think this is a useful question. With the rounds of invitation restarting, with express entry going on, let's jump right to it. So the question was, how do I calculate my CLB score and what is the minimum score that I need for express entry? So if we flip over here to the eligibility for express entry, we actually have three different programs. As you know, we have the federal skilled workers, the federal skilled trades, and the Canadian experience class. So if you're outside Canada and you haven't studied in Canada or no Canadian work experience, you're most likely looking at the federal skilled workers. All right, let's take a look here. We have the minimum requirements. So in the last Q&A that I hosted, I focused a lot about the skilled work experience, what you need as the minimum experience to apply for express entry. Now, we also have a language ability. In other words, you need to have a minimum language score to be able to qualify for express entry. So we can see here on the page, this is again for the federal skilled workers. There are various requirements for other pages. On the page, not for pages, there's the various requirements for other programs, so make sure you take a look at that. All right, so let's take a look at it, language ability. And here it says you need to take an approved language test, and you need a minimum CLB, Canadian language benchmark, of 7 in all 4 abilities, and you need to enter your test results on your express entry profile. It's valid for 2 years. So this is the general requirements, but what does it actually mean to take a language test? Well, let's take a look at it, right? So you need to do a language test that needs to be approved by IRCC. So let's go take a look. What is an approved language test? Well, we need to take in English, you have to take the Canadian English Language Proficiency Index program, and you need to take this specific test, the general test. We don't accept the general LS test for express entry. This is confusing, but important to know. Or you can take the International English Language Testing System, right? You must take the general training option. We do not accept the academic option for express entry. So very important that you have the correct language tests. In English or in French, you also have various options as well. Évidemment, un nom comme Cédric Marin, je suis un francophone, je suis né à l'extérieur du Québec, donc si vous voulez immigrer au Canada à l'extérieur du Québec, je vous encourage à m'écrire, à me contacter, j'offre aussi des services juridiques en français. Alright, back to the English. So when you take an approved language test, you need to have the minimum result required in your program. So what does it mean to have the minimum results? So we looked at eligibility for federal skilled workers, and you need a 7 in all 4 abilities. All right. So we have here are the abilities. We have writing, reading, listening, and speaking. Now, what does this mean, right? You do a language score and you have all these results, but how do you calculate the CLB? All right, so let's scroll down here. We're interested in the Federal Skilled Workers Program. Right here, it also talks about the Canadian Experience class, and we also have the Federal Skilled Trades. What we're really interested in is this table here. You'll see here if you keep scrolling down, here we have the different programs, and for the purpose of this example, what interests us is the Federal Skilled Workers. So you need a minimum of 7 in all abilities for the language requirement. So this means that when you do your tests, you're going to need for the CLPIP 7, 8, 9, and 10. Now this is pretty simple since it matches the CLB level, right? Pretty simple. All right, but what about the IELTS, right? This is another test. It's also a very common test that a lot of people will take, and here are the equivalencies. So to have a 7, CLB level 7, you need a minimum, a 6 in speaking, a 6 in listening. In reading, you need a 6, and in writing, you also need a 6. This means that if you have, for example, your reading is at 5.5, you do not have a level 7 in all 4 abilities, you do not meet the eligibility for the federal skilled workers, you cannot apply for express entry at this time. Thankfully, you can probably do a quick language test, study a little bit more, do another language test, and be able to improve your score. And you can actually see here, if you had a 6.5, right, in your speaking, this would be a CLB level 8. And while you, in this, would meet the eligibility, but you would also get additional points for your 6.5 in speaking. Right? So this is how we calculate it. This is an easy sheet that you can look at. This is by our IRCC. And again, you need to have a minimum, these are the minimum language requirements in all 4 abilities to be able to apply. Just make a profile and create a profile. Now, a few more things you need to know about the language. It talks here about 2 years, to be valid for 2 years, and you need to enter in your express entry profile. But what do they actually mean by valid for 2 years? So if we flip back to this page, you're going to see that it talks about, there we go, right here. So your test results must be valid, right? So less than 2 years old when you create your express entry profile, so from the very moment you create it, but also when you apply for permanent residence. So the way it works, as you know, if you've watched many of these videos, but if you're just joining us, the way it works is you create your express entry profile, and if you have the CRS score, the score cutoff, you're going to receive an invitation to apply. You have 60 days to apply for your permanent residence. So at the moment that you apply, not the moment you get your invitation, the moment you submit your application, your language results need to be valid. So very important right now, if there's a draw happening tomorrow, as it's expected, you're going to need to make sure that your language results are still valid up until you actually submit your application for permanent residence. So there we go. This is a short overview of the language requirement, how to calculate your CRS score, and what you need to do to meet the language requirement part. All right, let's flip over here to some questions, we have here Jules who says it's 5 a.m. in Brazil. Fantastic. Well, again, this is, if you're in the Americas, North America, South America, Latin America, I telework abroad, which is a fantastic opportunity to connect with you if you're an early bird and you like to work in the morning, work on yourself, work on improving yourself. It's a great time. I am available. She says, "Hello, sir. Hope you're doing well. I'm doing fantastic. You know what? It's a beautiful day here and a little bit of construction in my building, so I do apologize if there's some noise, but I'm doing fantastic." She asks, "What is the new update with the express entry system?" Thank you. So, for those of you just joining us, we have me and Alicia actually made a breaking news video that was published on Friday, and we were so interested in this video for a few reasons. So, what you need to do is if you have an active Express Entry profile, you actually need to go inside of your profile and you need to answer a few questions on your education. And so I don't want to talk about it again. We have a video called Breaking News, Important Updates for EE Candidates, and this specifically talks about education. So there was some changes to the education. Long story short is that during COVID, they allowed people to go back to their country to be able to follow courses via Zoom, like distance learning, and they're actually going to give you points for the between a certain period of time if you completed Canadian studies, but you were not attending in person. So long story short, again, just a very quick summary is that usually you need to be full time, you need to attend in person your course, and it has to be obviously in Canada, right? And if you take a Canadian program, but it's distance learning outside of Canada, you're not going to get points for this. However, they realize that during COVID, a lot of people need to get these additional points. It's just not fair because of COVID to take these points away. So if you have an active Express Entry profile and you studied in Canada, I strongly encourage you to look at the video on our website and learn more about how to update your profile. All right. Jules asks, if I get married after the AOR, so this is the acknowledgement of receipt, and change my last name, do I need to change all my documents or can I just upload the marriage certificate that states that I've changed my name? Jules, excellent question. This is a really, really interesting question, and to be completely honest, I think you would need to update all your documents, right? So you need to have valid documents, and I would presume that if you change your name, that these old documents with your old name might not be accurate. But what I'd recommend for you to do would be to actually reach out to us. We'd love to speak to you a little bit more about this, or you can also reach out directly to IRCC to see what the requirements are. I'm sure there's information about this, and it's quite uncommon that someone uh, changes their name in a after receiving the acknowledgement of receipt. Let's take a look here. So it says document requirements. So here we're talking about the actual operational guides. Let's take a look here. So only permanent residents and protected persons are eligible. So, okay, so this is to change your name inside Canada. To be honest, Jules, I don't know the answer to your question, but I would encourage you to definitely disclose it to RCC. Definitely provide a marriage certificate. I would assume that they would need to have all new documents to actually continue the processing of your file. But reach out to IRCC and see what they have to say. All right, J. Dave says, "Hello, sir. Any hopes for backlog for work permits for business category? Applied on the 7th of May, 2021." All right, Jay, you might have already done this, but IRCC, for a lot of programs, they actually publish a list for the processing times. So let's go have a peek here, and let's go down to your specific program. So here you're talking about a business, let's see here, work permit for business category. Let's take a look here. Self-employed Quebec business category. You're talking about a startup visa. It's under a different category here. So some cases they actually don't publish the specific processing times. So in your case, like for example, even in Canada, they group up all the work permits. They group them all together, right? So there's no work permit inside Canada. Whether it's an open spousal, whether it's an extension, they don't do a good job of talking about the different programs. We can see here that here's the expected wait time on paper or online. If you've applied May 2021, you're already talking about more than a year to process your application. And here, let's take a look at the outside Canada. Oops, sorry, study permit. Sorry, work permit outside Canada. There we go. It's your country of nationality. Jay, what is your country of nationality? Have a quick second if you just mind posting it. Jay, Dave, you're still with us. In any event, it's going to depend on your country of nationality. Let's put the United States. So take a look here. So right now, the processing time outside of Canada for the United States is 11 weeks. So this is if you've been waiting a year or more, and the processing times is actually outside of the the expected processing time, I would strongly encourage you to actually get in touch with us. So I recently wrote a blog dealing specifically with delayed applications at IRCC and the writ of mandamus. So in this blog, I actually explain what is a writ of mandamus. Mandamus is just an old Latin word that has been incorporated in Canadian law by the federal court, or by the courts more broadly. And a writ of mandamus is a judicial remedy to compel a public authority to perform a duty. So, long story short, in immigration, you can go to the federal court and you can ask a judge to issue a writ of mandamus, to issue an order to force IRCC to go ahead and render a decision on your visa application. It can be used for permanent resident application, work permits, temporary resident visas. But this is a writ of mandamus. It's a formal court action that you're taking against IRCC at the federal court. Now, I actually talk about what is the legal test for writ of mandamus, and here I highlight the most important parts. So here we talk about a unreasonable delay, and without knowing more of the details, I can't tell you that this is an unreasonable delay. There might be valid reasons that it's taking over a year to make a decision on your business category work permit, right? Are they looking at your business? Are they doing inquiries? Are you maybe responsible for the delay, right? And then on a balance of convenience, should the writ of mandamus be issued? So this means, is there valid reasons that the federal court should issue a writ of mandamus to force IRCC to render a decision? Now, I strongly encourage you to read the blog. I go into more details, talk about what are unreasonable delays and a balance of convenience. But in your case, it looks like we're well above again, I don't know your country, Jay, but it looks like we're well above of the processing times. If that's the case, you would definitely explore whether it's appropriate for you. The very first step of a writ of mandamus is that a lawyer is going to write a letter of demand to IRCC and the Department of Justice. And this letter of demand, you're going to clearly explain why you're demanding action from IRCC. It's giving them a chance to actually start processing your file to go forward and avoid to go through the litigation and avoid going to federal court. So that's the very first step. And I do want to point out that myself, I have experience with writs of mandamus in terms of getting the processing of files back on track when we meet the legal tests, in particular when there's a big unreasonable delay. So I have experience with these files, and in fact in 2017 and 2018 I was a law clerk at the federal court where I provided advice to judges on immigration applications at the federal court. So the very first step, we're gonna meet with you, get all the details, and write a letter of demand. And in some cases, it's actually successful. IRCC is going to start processing your case. They want to avoid litigation. They want to avoid having to go to federal court. And so here we have it. We have reached agreements and settled cases before litigation begins. This saves you time and money. The second step is that if they don't reply to the letter of demand after a few weeks, is you actually file an application at the federal court and you perfect the applicant's record. So here we're actually going to be detailing, providing a legal memorandum of argument to the federal court explaining why they should compel IRCC to render a decision. Now, IRCC might oppose it, they might negotiate after the factum, but the idea here, our approach, is try to reach settlements with IRCC to save you time and money. We have to go through, if you want to continue the action, if we're not able to settle at the letter of demand, we're not able to settle here at the applicant's record, they still refuse to process your file, we would need to seek leave at the federal court. So essentially we have to obtain permission to continue with the action with the application before we go to the actual hearing. So there's more details on my blog, but if you have a delayed application right now, it goes beyond the processing times and you are not responsible for the delay, I would strongly encourage you to reach out to me and to book a consult. So here you can actually speak to one of our lawyers at the Whole Immigration Law. We're an immigration law firm. We specialize in immigration law. Here at the bottom here we have Alicia, our colleague, fantastic, very knowledgeable, been practicing immigration law for quite a long time. We have here Chanel as well, and here we have Cédric. So here you have my time zone, how to reach me, and I do specialize in litigation, including rejected applications and reconsiderations, and including writ of mandamus. So feel free to reach out. I'd love to discuss your file, whether or not there's a reasonable chance of success, the next steps forward, and how can we get your file back on track to continue the processing of the case. And again, strongly encourage you to read about the delayed applications at IRCC and writ of mandamus to see if this is appropriate for you. And again, the delay has to be unreasonable. If you're waiting a few extra weeks, if you're waiting a month or two more in the processing time, it might not be unreasonable, but in your case, if you're waiting at more than a year and it should be taking about a few months, definitely reach out. I'd love to speak more about your case. All right, next question. Yeah, Dad says, hello, Cédric. Hi, how are you? All right, let's find questions. Ranjan says, hi, I'm having my ETSOL exam this September 3rd. I'm not sure if I see a question. But yeah, I did talk about everything about the IELTS exam. Make sure you have, again, just very briefly, make sure that you actually have you're taking the right exam. Where is it? You're taking the right exam, taking the approved language test, right? We saw that it has to be, for the EITSL, that has to be the general training option. It cannot be the academic option for Express Entry, right? And try to get your CLB, if you're applying for the federal skilled workers, to a minimum level of 7. Now, if we just flip back here, we actually didn't talk about the points for the language. We talked about it very briefly, but if we take a look here at the ministerial instructions, so this is the authority where you get all your points, and we scroll down all the way to actually, where's language? All the way to language. Let's continue. So here we talk about, sorry, let's, there we go. So official language proficiency. Here we are. So here, this is the actual, again, this is the authority. This is where you actually get the points under the law, under the legal regime. So here you can see here, the 2-year duration specifically talks about if the results are 2 years older or more, the points ceased to be assigned, right? So, and here we talk about the basis for assigning the points. And here you can see here, this is how you get the points, right? So I just want to note that you get points for each proficiency. Sorry, for proficiency in each language skill areas, right? So if you have a 9 in reading, you get 31 points. You have a 6, right? You have a 7, a CLB 7, you get 17 points for your speaking. Your listening is at a CLB 8, you get 23 points. So you really get it for each language skill area. And then if you have a partner, your partner, common law or whatnot, could also get points for their language, and if you have yourself a second official language, you would get additional CLB points. Now, we talked about this a lot in the last video, but if you're just joining us, fantastic. I just want to talk about transferability points. So transferability points is that you get points if you have a mix of various, you have a combination of various factors. Language and education, you get additional points. You could also here at the bottom, we have combination of education and Canadian work experience, right? We have combination of foreign work experience in official language. So let's take a look here. So if you have a CLB, so here you can actually get 13 additional points if you have 1 or 2 years of foreign work experience, right? And in your official language assessed at a 7 or higher, with no more areas assessed at less than 9, right? So here you get 13 additional points, and you can get up to 50 additional points if you have at least 3 years of foreign work experience and your first official language is assessed at a level 9 or higher in all skill areas. In other words, you get the points that we talked about at the very beginning to have the language score, and then you get the combination points here at the bottom, which is super important. So for a lot of people, improving your language score could be the easiest way to improve your CRS score, right? So there we have it. Let's flip back and let's look for our next question. All right, Paransa Nasuni. Hi, or hey, hope you are well. Wait time for Outland Spousal sponsorship is 24 months as per IRCC website. Can my wife visit on a visitor visa, or can I apply for sponsorship and then go back home? So interesting question regarding spousal. It's an interesting question. It's one that we do get quite often, and I think it's best addressed in a blog that that Alicia recently wrote. So let me just pull it up here. Talking everything about spousal. Let's try to find it here. All right, so let's flip over here. So this is our website, hopefully immigration law, and just to show you, go to our website at the very top here. We have our resources and then blogs, and then we have all these blogs that we write to really try to reach out and help you, help our clients, help people who are immigrating to Canada. And you're going to find some very specific blogs and some broader blogs that talk more about immigration law. And this is the blog that I think really answers your question. It talks about inside versus outside Canada spousal sponsorship, and this is written by Alicia. So Alicia, lots of experience with spousal, lots of experience with dealing with these types of situations. You can speak to her at the very top here, speak with a lawyer, as we talked about, consultation, and here is Alicia. All right, let's flip back here to the blog and to your question. So there's various, so when we talk about spousal applications, we talk about doing the in Canada class, and we talk about outside Canada, family class, outside Canada. So the inside Canada class, here it actually talks about who you can sponsor. Whoops. My Chrome has crashed. My Chrome has crashed. All right, well, oh, that's so odd. Anyways, here we have a chart that helps you understand who you can sponsor, what's the right of appeal, what can happen in various circumstances, what are the processing times, what are the advantages or disadvantages between the type of spousal. So in your question, you actually don't, in your question, you see the outland spousal is 24 months. Can my wife visit on visitor visa, or can apply for sponsorship and then go back home? So it's generally speaking, when we're talking about an inside Canada class application, we usually recommend, unfortunately it's too small, but we have it here inside of our blog. We usually recommend that the the person being sponsored, so your spouse, would not leave Canada, because at any time, if they leave Canada and they're not able to come back to Canada for whatever reason, whether it's travel, whether it's a visitor visa rejection, whether it's being rejected at the border, it could actually put the application at risk. So we generally recommend that if you do it in Canada spousal, that the person tries to maintain a valid status inside Canada and does not leave while the spousal application is pending. That's just general rule of thumb, but it's hard to, we don't give legal advice on the videos, we provide legal information, right? So there's various scenarios where we see individuals who, for example, want to come to Canada, apply for the in Canada because they want the open spousal work permit, but yet are gonna leave outside Canada, and they might not be able to come back to Canada. They might not be able to come to the interview that's scheduled by IRCC. The second issue that you might have is that when you come back to Canada, the CBSA at the border are going to be looking at your temporary intent to remain in Canada, but at the same time, they're going to see that you have a spousal application pending, right? So if you're not married, if you don't have a spousal application, these are all factors that could go into the decision of not being able to re-enter Canada if the immigration officer believes that you're not going to respect the temporary intent and return to your home country. So it's very difficult to talk about whether or not they should stay inside Canada, whether they can leave and come back, whether or not you should do outland or in Canada. It's going to depend on your immigration history, your country of nationality, the strength of your relationship, whether you have an application pending or not. There's so many factors that are just unknown that I can't talk to you about right now. You can try to look at, can't talk to you about because I don't know enough to talk about your specific case, but take a look at our blog here. It talks about the different types of forms, the pros and cons, who can be sponsored, what matters and whatnot. A great blog by Alicia, and if you want more information about spousals, about your specific case, please do book a consultation with us. All right, Manoj Kumar Murugensen says, question, I have a work permit, came to India, waiting for TRV for 7 months now. Mark recommends to work with you on a mandamus as it affects my work. Can we? Yeah, you know what? This would be a fantastic case to explore in more details to see whether or not a mandamus application is the right case for you, right? As we've talked about mandamus just moments ago, but in short, we're dealing with unreasonable delays. If we take a look here at the delay time, at the processing times at IRCC, and we're going to go into permit from outside Canada, and we're going to pick India. Processing time right now is 45 weeks. And in your case, you've been talking about 7 months now. So it is inside of the processing time that is expected. However, 7 months for you have a work permit. You're waiting for your TRV. Sorry, for the TRV. Let's take a look here. Sorry, visitor visa, India. 162 days. So here, being at 7 months, you are over the processing time for IRCC, and so the very first step for me and you would be to meet in a consultation to learn more about your case, learn more about the timeline of your application, and the very first step is going to be to work together to draft a letter of demand. So it's going to be a letter that we're going to work with you to draft and prepare for IRCC and Department of Justice, and we're going to give them, let's say, 3 weeks to start the processing of your file, or else we're going to go to the federal court to bring forward an application. So this is the very first step. We have had settlements as soon as we send this letter within a few weeks. Again, each file is different, and there's no guarantees, but we're going to work hard and do our best to make sure that we have a strong letter of demand so that we don't have to have further litigation. So definitely recommend it. I mean, you're over the delayed processing time. It's impacting your work. I think a writ of mandamus could be a very, very strong option for you. Again, legal information. When we meet in a consult, we provide legal advice. We look more at the actual facts and to see how strong your case is. All right, let's flip back. Ria Carr says, my question is about spousal sponsorship. If the principal applicant himself, herself, do all the process for spousal sponsorship, is it necessary to fill the use of form IMM 5477? All right. So the form that you're talking about, let's just flip to it, is for paid immigration services. So in your case, I think you meant 5476. Just flip to it. Sorry, just give me a moment here. Again, I am new to I am new to do my own streams, so I do appreciate your patience, guys. Let's just pull this up here. So there we go. So this is really, the user representative is really if someone has provided advice or guidance to you at any stage of the application process. So if you're working together to submit your application, in the case of a spousal, oops, the chat disappeared here. There we go. This use of representative, like your spouse is not being a representative, they're not providing advice or guidance. You guys are working together to submit the forms, right? So there's no use of representative. Typically lawyers are going to submit this form. Immigration consultants as well will submit this form. Anyone who has provided advice or guidance to you at any stage of the application process. But here, like, we're not talking about a spousal application working together to complete this form. Here we're talking about, someone advising you, saying, do the spousal, do this, do that, right? There's only certain individuals who are legally allowed to give you advice on immigration matters. We are immigration lawyers, and right now in our live Q&As, we provide legal information, not legal advice. However, if we take a look here, IRCC paid representative, the IRCC talks about who is allowed and not allowed to. Oh, here we're actually in the passport. So representatives. So there we go. So we talked about paid, and then we talked about unpaid representatives. So authorized paid representatives are only someone who can charge a fee for services, right? So here we're talking about lawyers and paralegals, such as me, or lawyers here to hold the immigration law. And then in Quebec, you have also notaries, and after here we also have consultants, immigration consultants who are in good standing, in other words, licensed with the College of Immigration and Citizenship Consultants. Now, this is just for the paid representatives for immigration, for some immigration things. Only lawyers can bring forward applications at the federal court, such as a writ of mandamus application at the federal court. Here we talk about unpaid representatives, right? So here we're talking about family members, friends, and whatnot. No fees, and again, beware of fraud. Mark has his segment as well that he does on fraud. But people who tell you, for example, they guarantee you to get your work permit, they guarantee you an LMIA, they talk about getting you a job offer if you pay a certain fee. This is all fraud. This is illegal. If you've used one of these services, even if you get your citizenship, in some cases they can look back at your applications for immigration law, and if you obtained a status under false pretenses or through fraud, they can revoke those statuses, right, going back. So very serious stuff. Beware of fraud. Beware of people who advertise free services and later ask you to pay you a fee, or advise you to lie in your application, or make false promises, right, like, pay us $100 and we'll find you LMIA, or give us 20% of your salary. So all of this is not allowed. And again, this is only in cases of people who explain and give advice, who help you choose the best immigration program and whatnot. So to answer your question, Ria, your spouse here is, they're not explaining or giving you advice. If anything, they're part of this application for some of the forms, and you're completing the forms together, right? So there's the use of is so unless if here's when they have to complete the form, and again, I assume this is not the case, but I don't know. But in most cases, the spouses don't have to complete a use of representative form because they don't do any of these things here. All right, let's flip back to our questions. Gunner boy, hi. It's 4:25 a.m. in Toronto here. Super early stream, I see. Hoping the postgrad work permit extension is released this week. Gunner boy, thanks for joining us. I see you on every live stream that we do. Thanks for your loyalty. We love having you here. Gunner boy, I telework abroad, right? My partner works abroad, so I do spend a lot of time abroad, and I do spend time in Ottawa as well. So right now I'm abroad, and this podcast is for people who can't join because the time doesn't work well for Mark or Alicia's podcast, live Q&A. So I have mine at this time, which is really early in Toronto, but allows people who are abroad who have questions to ask these questions. Post-grad work permit extensions. What is going on, right? So rumor has it, and I say rumor because it's not official, but rumor has it that the post-graduation work permits are going to be announced this week. That's the rumor. Again, this is not, Cédric says, it's not an official source. Why do people believe this? Well, let's take a look. IRCC newsroom. So what happened is the immigration minister, the federal immigration minister, met with the provincial ministers who are responsible for immigration, and they met at a forum, and they chatted about immigration. And here is the news release. Now, there's no mention of post-COVID, but no post-graduation. No mention as well as like the abbreviation PGWP. So, but they were asked actually during this meeting, they were asked what is going on with the post-grad work permits, right? I have a lot of clients whose permits are going to expire like next week. So this is super serious stuff, right? The minister said that they are expected to release it this week. So stay tuned. If you have questions about how to renew it, whether you qualify and whatnot, we've talked about on this podcast on the live Q&As, but we actually don't know what's going to happen. So we're gonna keep you informed. We're gonna have a video very quickly done as soon as it's announced. We're gonna go live, and this also, if you want to speak to us about it, you can go on our website at the very top, speak with a lawyer, and we'd love to help you out with your post-grad work permits. Love to help you out with your application. Mark has also prepared, right? We are the Canadian Immigration Institute. He's also prepared a class to help individuals prepare. So if you Google Canadian Immigration Institute, it brings us here to your website, and we do have a course at the very bottom here. We have a course on express entry. It's actually going on right now. We also have another course. You can learn more about it right now and register for the course. And as soon as it's announced, it's going to go live. This is all about the extension. It's going to talk to you about who can apply, how to apply, and common mistakes to avoid in immigration applications. And if we look here, we have two options. So we have the live access only. So if you just want to ask questions to Mark, take notes, access the live, it's $25. I think this is one of the cheapest ones that we've ever had. If you do want to actually join the masterclass, have access to 2 days of Q&As with Mark, get access to the community, get sample documents. Here's our price, and here's how you can apply right now. So we do have a course. We have different levels to engage individuals. You can join us on a live Q&A as we're doing right now. You can book a consult. We can give legal advice on your case. You can join a course, and the course is going to be with other individuals, and we're going to do our best to help you and guide you through the process with others. Or you can also hire us to do it for you, right? So we do offer legal services to sit down with you and properly prepare applications to avoid common mistakes and processing times. All right, let's flip back here. Thank you, Gunnar Boy. Great question. I know it's on the mind of a lot of people. So, great question. And again, as soon as it's announced, we're going to go live and we're going to share more details with you. I've mentioned this as well, but I don't know how Mark talks for an hour without drinking anything. I need to drink. My mouth gets dry. So we'll just put it out there. All right. So again, we don't do the questions by order. I try to find questions that can apply to everyone. There's some questions that are very specific and you might need to speak with a lawyer. So I do want to have a good mix of questions where it applies to everyone and questions where, I'm not just saying speak with a lawyer, speak with a lawyer, speak with a lawyer. So I want to provide legal information that can really help you out. So let's get to it. All right. Hidal says, "Hi Cedric, I got refusal for study permit before, and I got a UIC. So this is I forget the exact acronym, but it's a unique identity client. It's a number that IRCC gives you, which essentially identifies you. It's actually UCI, unique client identifier. And this is a number that on your immigration applications they're going to ask for to identify you, right? So in your Express Entry profile, in your Express Entry profile, they're actually going to ask you if you already have a UCI, and you should have actually been able to enter your old UCI. So go to your Express Entry profile, try to modify and look at the answers that you've answered. If you've enter your UCI inside your Express Entry, and you should only have one UCI number with immigration. So there we have it. Next question, could the fact that I got several refusals in the past for the study permit application have an impact on my EAPR? So EAPR is an electronic application for permanent residence. So in Express Entry, create the profile. If you meet the minimum score for the draw, your name gets called. Get invitation to apply. 60 days to submit your application. And when you submit it, that's your application for permanent residence. It's the EAPR. So the question is going to come down to why did you get refused for your study permit application? So the study permit is a temporary intent. You come to Canada to study with the intent to return to your country, right? The EAPR is a permanent intent. You're coming to Canada as a permanent resident to contribute to Canadian economy, pay Canadian taxes, Canadian work, Canadian culture, and so on, right? So it's a permanent resident application. So it's going to come down to the reasons for refusals. So if you're rejected for your study permit because, for example, you did not demonstrate a temporary intent to return to your country, well, with a permanent resident application, there's no temporary intent, right? So it should not be a factor for your EAPR, for your permanent resident application. Another example could be you submit a study permit application, but you don't actually have all the documents. You submitted the wrong documents. You didn't have your letter of acceptance, right? And so you're doing a new application for permanent residence. The fact that you did not provide a document in most cases will not have an impact on your permanent resident application. However, here's where it gets more serious. If your study permit was, for example, refused for misrepresentation, you have lied or you misrepresented facts on an immigration application, or you were found inadmissible for criminality or other for other more serious reasons, this will have impact on all your immigration applications, including an EAPR, right? So it really depends on the reasons for the refusal. If you receive a procedural fairness letter, or you have received a misrepresentation, a letter that says you were rejected for misrepresentation, I highly recommend that you speak with a lawyer to see whether or not you can appeal it, to see if you can overcome the refusal, right? The reason why is that in some cases, you're going to have a ban on applying to Canada for a certain number of time. Usually it could be 5 years for misrepresentation. And Canada has information sharing agreements with other countries, notably the UK and the United States, which means that if you just, you misrepresent in Canada, whatever, I'm just going to apply to the UK or the United States. they're able to see the information that you provided on previous immigrations in Canada. And a lot of times on those forms, they're already going to ask you, have you already been found inadmissible? Have someone already rejected you for a study permit or visa and whatnot? And you have to disclose it. And if you don't disclose it, like I said, they have information sharing agreements. So you want to get that fixed. You want to look at whether or not it was actually a misrepresentation that was made in your case. You want to look in detail to see what is the criminality that you're being accused of. What is going on with the inadmissibility? You want to get that overcome to get that fixed. So though it's really gonna have to do with what type of refusal for the study permit. Some cases no impact, some cases yeah serious impact. And again, uh, it's hard. We just give legal information. If you'd like to speak with us, I do have experience with misrepresentations. I do have experience with federal court applications to at the federal court for judicial reviews. I'd love to speak to you to learn more about your specific case. All right, Trevor. Interesting question on the LMIAs. So before we talk about your question, I just want to talk about what is a LMIA. For those of you just joining us, new to the podcast, welcome. Uh, let's talk about labor market impact assessments. All right, so let's flip over. We have a handy dandy question by IRCC in the Help Center that actually answers this. So LMIA is a document that an employer in Canada may need to get before hiring you. All right. Positive LMIA will show there's a need for a foreign worker to fill the job in Canada. It will also show that no Canadian worker or permanent resident is available to do the job. If the employer needs an LMIA, they must apply for one. All right, well, let's go take a look. What do I need to apply for one? Well, the first thing you need to know about LMIAs is that it is, oh, this link doesn't, there we go. So the first thing you need to know about LMIAs is that it's an employer-driven process. Your employer, a business, is going to be the one requesting the LMIA and preparing the LMIA. Right? So they need to prove that they have a business need, they have a legit business, right? There's various requirements. They have a legit business, and they need to hire a foreign worker because they cannot find a Canadian citizen or they cannot find a permanent resident to fill this job. So you can imagine, for example, in a business that does X-rays needs to hire a doctor, and they can't find any doctor in Canada, right? They can't find a doctor in Canada, a permanent resident, a Canadian citizen to as a doctor. And so what they have to do is there's different requirements depending on the job, depending on a high wage or low wage position and whatnot. But in short, what they need to do is actually prove, they need to make a job advertisement, usually for 4 weeks, if not longer in some cases, and try to find someone, recruit someone. Very strict guidelines in terms of posting and whatnot and how to prepare it. And then if they're not able to find someone, they can submit an application for the LMIA. They have to pay the $1,000 fee, as you mentioned in your question, Trevor, and they need to prove the LMIA. Now, the chances of an LMIA getting approved is very, very, very specific on who prepared the LMIA application and why they're requesting the LMIA application, right? In some fields, there are tons of Canadians and PR applicants and PR individuals who can do the role, right? So there's no reason to apply for LMIA if you're able to find a Canadian or PR. In some other fields, depending on the region, on the occupation, there is less people that are available to do the work, or that don't want to do the work, or can't do the work, or they're just not, they don't want to apply or can't apply for whatever reason. The company can't recruit them. So it really depends on the field of work. It really depends on the on the availability of Canadians or PRs. The next step after the LMIA is that if you will need to get a work permit, right? The individual, if your name in the LMIA, you need to get you will need this individual will need to get a work permit for Canada. And then in some cases, if you require a temporary resident visa, you also have to apply to a temporary resident visa. So when we work with our corporate client, so we do have corporate clients as well that we assist, and when we deal with the LMIAs, the first thing we look at is whether or not you need an LMIA, because there's LMIA exemptions. In some cases, depending on the country that you come from and depending on the international agreements with the country, depending on public policies, we can actually switch over here and look at the LMIA exemption codes. And so you can look, for example, for mobilité francophone, which falls under Canadian interests. We have here the mobilité francophone. Oops, mobilité francophone mobility. There we go. Oops. Sorry, I'm just resizing this. Francophone mobilité. So under certain cases, if you fall under the francophone mobilité, significant benefit, you would not need an LMIA to come to work in Canada if you work outside of Quebec in a NOC A, if a NOC O, A, or B, right? In some other cases, if you're currently in the United States, there are agreements with the United States that allow for some professionals to come to Canada under certain professions, to come to Canada and to work in these professions. So let's take a look. So here we talk about the NAFTA that's been superseded by the CUSMA agreement, as I'm sure many people are aware. And here we talk about different categories of individuals, different free trade agreements that allow individuals to come to Canada without LMIA. So again, business professionals, it gets a little bit complicated. So I do encourage you that if you think you fall under one of these LMIA exemptions where your employer does not need an LMIA, you can come to Canada with the LMIA exemption for a work permit to reach out to a lawyer. We'd love to help you out to see whether or not you actually need an LMIA, right? If we go back to Trevor's question, some individuals will need an LMIA because they don't fall within the exemption codes. And if we take a look here to the ministerial instructions, you can get additional points for your express entry profile. For invitations. Sorry, just trying to find the ministerial instructions. There we go. So you can actually, if you're right now outside of Canada or even inside Canada, you can get additional points for qualifying offer of arranged employment. And what is a qualifying offer of arranged employment? In a lot of cases, it's going to be getting an LMIA. So the LMIA is submitted to the Department of Employment and Social Development. And when you have a positive LMIA, you can get additional points for get up to 50, up to two, where is it? Sorry. It's up to 200 for double O. There we go. 200 for double O, or 50 points for the qualifying offer of arranged employment. So any other offer. So for express entry candidates, this is another way to increase your CRS score. If you're abroad right now and you want to come to Canada to work, an LMIA in most cases is going to be needed, right? You're going to need an LMIA to come to Canada to work, to get a work permit. In some cases, as we talked about, you might be LMIA exempt. You might be able to get a work permit without an LMIA. In those cases, a little bit more technical, but you can definitely do it. Definitely reach out to one of us. We'd love to help you with that. All right, let's find, again, we're trying to find some questions that we can talk, give like a big overview that's helpful to everyone. I apologize if your question is being skipped. In some cases, the best option is just book a consult and speak with a lawyer. If it's very specific, again, we don't provide legal advice over YouTube. All right, Rashpal says, question, in address history, should I put in addresses of places where I traveled outside Canada for more than a month, also back home country, moved across multiple homes in 2 years, list all? Yes, Rashpal, I would list everywhere that you've been, where you've resided, even if it was 2 places in 1 month, right? So if you're going on a vacation for a week or two, well, you're not residing at that place on vacation, right? However, if, for example, like me, I telework abroad, I come back to Ottawa, I go abroad again to telework. I'm residing, right, at different different addresses at different times, right? I have my usual day-to-day life. I telework from home. These would be my addresses. So the first thing I would recommend is look at the immigration form that you need to answer and look at the question very specifically. But if we look at a very common form, this is called the Schedule A form. Let's just switch over here. So here we go, Schedule A, background declaration. This is the one I believe you're talking about. And if we go here at the bottom, we have addresses. So here are addresses. The question says, list all addresses where you lived since your 18th birthday or past 10 years, whichever is most recent. So past 10 years, if you're like 11 or 12 years, you know what, I would just list all the way to 18. Sometimes immigration officers will ask you for more addresses. So I would say 10 years is what the question asks you. If you can list 11 or 12 to go back to 18 years, fantastic. And here, yes, I would write every single place you've resided that you've lived in the last 10, 12, since your age of 18, right? So yes, in your case, for example, let's say you were in New Zealand, right? We put New Zealand here, and even if it was just for 1 month, let's say this is how you would do it. And after, let's say in the same month, you lived here for a week, and then you moved to Australia, right? So again, we would put this here, and then obviously you would continue filling in all the information, and then here you could have, and after Australia, you lived in the UK for, for just a little over a year. So this is the way that I would do it. Just really have it very clear as to where you resided, disclose all the information when they ask you about it. All right, so there we have it. All right, Tiana White, interesting question. One that we receive for various reasons. So let's get right to it. I think it does apply to a lot of people. So Tanya White says, Hi Cédric, my brother received his confirmation of permanent residence recently and arrived in Canada on July 17, 2022. Here's the follow-up question. I'm currently in the express entry pool. How soon can I claim my siblings' points? He hasn't received his PR card yet. So the question I would actually ask is, so he got his confirmation of permanent residence. He arrived to Canada, right, on July 17th. And so at that point, when he got to the immigration officer, he got the letter, it was signed, and that's at the moment that he receives his permanent residence. However, in your case, how early can you claim them is an excellent question. To answer your question, we're going to go take a look at the ministerial instructions. So again, this is where you find all the legalese about the points. This is the legal authority to get these points. And let's talk about sibling in Canada. So here it talks about the nitty-gritty of when you get points for a sibling in Canada. So 15 points may be assigned to a foreign national if they or their accompanying spouse or common law partner has at least one sibling. Again, sibling, brother or sister, right? Who is 18 years or older. All right, let's just assume that your brother is 18 years or older, Canadian citizen or permanent resident, and living in Canada, right? So, based on the information you provided, clarification. This is what it says. For the purposes of subsection 1, a sibling of a foreign national or the foreign national's accompanying spouse is the biological or adoptive child. Oh, there we go. So this defines what we're talking about. This defines siblings, right? So here we go. So here they actually use the term or, so of their father or their mother. So this actually siblings would include half siblings, right? So the case where you have a brother, but they don't share the same mother and father, sibling counts. And same thing, spouse. So if, for example, your father or your mother was to remarry, they have a spouse, and the spouse has a child in Canada, that would count as a sibling. So again, important, but in your case, you just talked about your brother. Yeah, you talked about your brother, so that's fine. All right, and then, so this is, so if he's living in Canada, and he signed, so he's in Canada. The confirmation of permanent residence was signed. Again, when you would get the permanent residency at the time that the copper signed the PR card, is helpful. Is usually used to travel, right? As identity, also used to travel. Um, but again, if you meet the requirements here, you could look as to whether or not you're able to claim the points to check the confirmation of permanent residence was signed at the border and that they are living in Canada. All right, let's look for our next question here. Yeah, so actually, sorry, just going back here just to confirm. So if we just go to the help center here and confirm, what does the immigration category mean? So we can see here an immigration officer at the port of entry or IRCC officer signs and dates this document when permanent residence is finally granted, right? Permanent resident uses document to show to provincial and territorial organizations access services, right? So when we talk about the actual PR card, the PR card is obviously important. Please apply for one as soon as you have your PR, but you obtain your PR when you come to Canada. The officer signs and date it. This is very important for a lot of reasons, right? Your confirmation of permanent residence has an expiry date, right? You have to go to Canada before the expiry date. The PR card, again, very important, mostly for traveling, but the PR card is super important. The PR card does not give permanent residence. It's really this document here, once it's signed and dated, that you obtained your permanent residence. Just curious to see, yeah, talk about the different programs under which you were approved. Um, there we go. It talks about the PR card. Let's see. There we go. Talks about when you obtain your PR card and whatnot. But again, you need to apply for the PR card, and you're going to need it if you're going to be traveling inside and outside Canada for sure. Definitely recommended. All right, let's flip back over. Hardik. Hi, Cédric. Question. Spousal open work permit application, almost 1.5 year waiting for final result. So as we talked about, there's the in Canada and there's the inside Canada class, and you have the family class outside Canada. And when you're dealing with the inside Canada, so if you apply from inside Canada for spousal application, your spouse can get an open work permit. Wow, this takes I that's a long waiting time. That is quite a long waiting time. I mean, we can check the processing times. Let's flip over. Here we're talking about a uh, a work permit from inside Canada. So right now it should take 163 days. So Hardik, you are well above the processing times for your spousal open work permit. Um, and yes, you're correct. Most files in 2022 have a final result. Why not 2021? I would encourage contact me. Um, if you meet the tests for a writ of mandamus, unreasonable delay, right? They're not waiting for any documents. You're not responsible for the delay. The very first step is for us is going to be to meet, to get all your documents, to get a timeline of when you apply to further understand your case, and then I would draft a letter of demand to IRCC to demand that they start processing your spousal open work permit application right now, or go to federal court to get an order from the judge to compel them to process your case. Um, should I reapply? Question mark, question mark. Interesting question. If you already have an application that's pending, they should be processing that application. You would essentially be going back into, you could just find you'd be going back into your initial application. It's possible that having two applications Two spousal open work applications made under the same spousal application may delay the processing. They might not understand why there's two spousal applications pending. And the best course of action here would be to go forward with writ of mandamus. I mean, your delay is quite serious. All right, got a CRS score of 415 as a baker and trade certificate holder. I get job offer from New Brunswick, but waiting New Brunswick 004 form from 50 days. I'm not very familiar with the federal skilled trades in New Brunswick. Very specific case with the baker and your trade certificate holder. Definitely. So here I presume your question, RM, is actually about the delay that it's taking. So for sure, contact New Brunswick. Try to call them, try to email them, see if they're able to get you this form. When we talk about more broadly about the federal skilled trades, and we're talking about CRS scores, we can actually go over here on our express entry rounds of invitation. Again, we widely expect to have a draw for the CRS for express entry for no program specified. We expect it tomorrow. So fingers crossed for all of you who have a pending express entry profile. And I just want to go over the CRS score. So here's the last score, July 20th. Here is the last CRS score of 542, extremely high. And here's everyone here in the pool. So a lot of people before COVID, the scores were averaging about 460, 470. And for federal skilled trades, we're probably looking closer to about 350 or 400. In any event, right now, for no program specified, there's a lot of individuals waiting for express entry. So we expect this to go down in a year or two to go back down to closer to 460 for no program specified. Right? But again, a lot of individuals. We're also expecting occupation specific and region specific express entry draw. So regardless of your CRS score, if you qualify for express entry, you might get called. You might get an invitation to apply based on your permanent residence status. No, sorry, not permanent residence status. Sorry, your NOC code, the NOC code for your job, and then you could possibly get your permanent residence. If we look here at the previous rounds, right, we know that the no program specified for express entry has reopened after being closed for about 2 years because of COVID. We see here the CRS score is slowly dropping. During COVID, there was only program PNP draws that were happening. If we continue, we see also some Canadian experience class draws for individuals inside Canada, right? So the score was a little bit lower. But if we go all the way back to before COVID, right? Oh, during COVID, there's a federal skilled trades, 415. There's your CRS score. So if you had applied at this time with 415 under the federal skilled trades, you would have gotten an invitation. If we go back here to before COVID, you can see here that the no program specified about 460, 470. And you can see here the federal skilled trades was about 357. Go again before COVID in 2018, 2019 with some lower CRS scores. And again, the federal skilled trades tends to be lower. In your case, I'm not very familiar with what's going on in your case based on the information you gave me. When you have the job offer from New Brunswick with an LMIA, right? Or if you're LMIA exempt, if you have the LMIA, you might be able to get additional points for your CRS score. And if you're waiting for a form from New Brunswick, whether it's for the PNP, whether it's for your express entry, there's various programs that you can apply under to obtain your permanent residence. So good luck with that, RM. Spider-Man says, hi Cédric, Spidey here from Melbourne, Australia. Spider-Man, welcome. Writ says, do multiple infringement on Victorian Aussie driver's license matter. None of them are DUI. Too much speeding. Or hit and run. I just have many red light and 3 to 5 km/h speeding infringement. It's difficult to. So what we're looking at is is admissibility under the IRPA. So let's take a look at the Immigration and Refugee Protection Act. Let's go take a look here at admissibility. So here are all the reasons as to why you may be inadmissible. And what we're interested in your case is we have serious criminality, and then we also have criminality. So there's different. The law is going to say that in some cases individuals are inadmissible for criminality or serious criminality or both. In your case, right, what we're interested in is the punishment, and what we're looking for is what's called the equivalence in Canadian law. So having committed the act in Canada, right? So what is your speeding ticket? What is your the red light violation? Is there a distracted driving? You said no hit and run, but like what is the actual crime, the statute, the infraction that was committed in Australia, and then what's the equivalent of this crime in Canada? And after, it depends how it's punishable. So if it's punishable by way of indictment, or if it's punishable indictments, we also have, so there should be summary conviction. Here doesn't talk about summary conviction, but indictment, it would be the more serious criminality in Canada. But take a look here to see whether, I mean, it's kind of hard for individuals to look at this to see whether or not it's serious criminality, whether it falls, into one of the applications. Is it either summary conviction, summarily, or by way of indictment? So it depends on how it would be prosecuted inside Canada. Usually with small speeding tickets, with a speeding ticket, it would not be by way of indictment. In other words, it would not be what's called the hybrid offenses. So in most cases, for small speeding tickets, it would not be an inadmissibility. But again, I don't know the very specifics of your case. I don't know what the equivalent is in Canada. I don't know what charges or infractions you've been brought forward in Australia. If you could actually look at the criminal code, Code Canada. Here are the criminal codes. Here are all our offenses, and then for you, a lot of the driving offenses in Canada are actually punishable under provincial laws. So in Ontario, for example, we have the Ontario Traffic and Highway Act, which talks about all the infractions. Here at the federal level, you have the criminal code. So a lot of questions to look at when we talk about criminality can get a little bit complicated, and we would encourage you to speak with a lawyer to try to assess the criminality, right? Again, small infractions like speeding, most likely not going to fall into criminality or serious criminality. But again, in your case, it looks like you have multiple red lights, multiple speeding tickets. What's the nature of it? What's the equivalent in Canada? A lot of unknowns with this question, but it's a very short overview of what a lawyer would do to help you into determining whether or not it falls into criminality. Canadian Soul say, hey guys, I got my PR yesterday. Thanks for the information. You're welcome. Congratulations on your PR. We love to provide these live Q&As to help you out, provide you with more information. All right. Sorry, just give me a moment here as I pull up the next question. We have going for an hour and 15 minutes. We have maybe another 15 minutes before I need to go to my next appointment here. Canadian Soul says, love from India. Congratulations, Canadian Soul. Thank you for sharing. Thank you for sharing this with us. Greener Voice says, congrats. And let's go to our first paid question here. Hardik. Paid question. There we go. I answered your question, Hardik. Again, we've talked about this. From on the information you presented, it looks like your delay is unreasonable. The next step is to send a letter of demand to tell them of our intention, to explain your case, and ask them to reprocess your file. All right, 483 CRS. What are the chances of getting an invitation before the year end? All right. Kind of already answered this question briefly, right? We looked. The way you can do it, where's my tab here? Oops, my goodness, so many tabs open. It never ends. The tab we want is not even there. So let's go to our, we can talk about the CRS calculator. Actually, it's not a bad idea, but let's talk about rounds of invitation. So again, we're widely expecting another CRS draw tomorrow. We're going to expect this to drop lower, right? We don't know how many people they're going to take. Depending how many people they take, it's going to drop the CRS score, right? So right now we think that it's going to stay over 500 for the next 6 months if they continue to take 1,700 individuals every 3 weeks. So if they increase the draws, if they increase the amount of people they take, and assuming there isn't like thousands of applicants with 500 scores, 500 CRS scores, we assume that it's going to go down in the next 6 months. So your chances of receiving an invitation to apply in the next with 483 in the next 4 months, I don't know. I'd say maybe 70, maybe 50, 70%. It's really hard to tell. It's really hard to tell right now. It's possible that they stop the draws. It's possible that the draws accelerate. Tomorrow they could take 10,000 individuals. We have no idea of knowing, right? So we don't know, but I think a good estimation would be 6 months, 500 and more within the next year, probably looking at 480 and whatnot. So Nirali, what can you do to make sure that you're ready for the express entry draw? Well, Mark actually has a video. Let me just get right to it. Mark has a video that talks about how to prepare for your express entry. So you want to obviously make sure your language results are going to be valid up at the time you apply for your PR. You're going to want to make sure that you have those police certificates, that you've selected the correct NOC, you have letters of reference from your employer, right? You have all this evidence that is able to demonstrate that you are able to, that you have the proper NOC, you have the work experience, that you have claimed, right? And all your documents are up to date. Mark has a video. Let me just switch to it. Let's just try to find it. It talks about how to prepare. We have so many videos here. We have NOC codes, we have reference letters. Can you use 2 NOC codes? Take a look at our YouTube. We have also top 5 express entry mistakes. We'd love to help you out right now to make sure that your profile is correctly prepared. We'd love to help you out when you receive your invitation to apply. You can head over to our website here. On our website, Speak with Lawyer. It's the very first step that we do to understand your case and give you legal advice. We have Alicia, who also does her live Q&As on Thursdays. We have Chanel, and I'm here at the bottom. We have Mark as well, if you'd like to speak with Mark. And what we do is we have what's called our collaborative review approach. So we don't work with immigration consultants. We don't work with law clerks or legal assistants. You work one-on-one with a lawyer, and that's where you get the most value, right? We take this stuff very seriously. We have experience with express entry. We have experience with helping our clients. So the very first step that we do is we meet in a consultation and we talk about, your express entry profile, and we review the best immigration strategy. Right now, Nirali, you already have your CRS score, and I assume you already have a profile. If not, the very first thing that we would do is work with you to make sure you have all the correct documents to create your express entry profile. So we're going to talk about your situation more in detail. Are you married? Do you have kids? Where have you lived in the last, in the last 10 years? More about your experience, and we're going to be looking to ways that you can improve your CRS score. 43 is really good, but if you're looking for ways, for example, is it going to be studying French? Is it going to be improving your English, finding a job offer? We actually help you with talking about ways to plan and make sure that you're maximizing your express entry points. We provide you with a Dropbox link, with a box link, where you can go ahead and drop your documents inside. You can share your documents with us, and we're going to review them one by one to make sure that it meets every requirement for the express entry. And we make sure that your profile is correctly prepared. We review the documents with you, we sit down with you, we go over the PDFs, right? So we ask that you do a first draft, and we go over line by line of every document. Is this correctly done? Okay. Is this family name, given line, your date of birth? Some of this stuff, and what this does is when you enter it once and when I review it, we avoid making mistakes. We avoid common mistakes in preparing forms, in preparing applications. We talk about these questions. What does it mean to have been it's a question, what has to be convicted of a crime, to have been charged with a crime, to have been refused admission of a country, right? So we talk about these questions, and we also help you prepare letters of explanation as to why certain things in your profile need a certain explanation. So we meet with you as much as you need, we work with you on this approach, and we work together to prepare, to correctly prepare applications. So we'd love to work with you. If you don't have an Express Entry profile and you want to learn more about Express Entry, please book a consult with me. I'd love to speak with you. Again, right now is a great time for me at Telework Abroad. So if you're early morning in Canada or if you're abroad, you can see the time zones at the very bottom. You can see the time zone that I'm at, a lot of availability. And if you can't find us a calendar slot, please write to us. I'd love to make room for you. All right. Adnan says, hi, what about having a job offer from a Canadian employer on postgraduate work permit, but not on LMIA? Is LMIA required? So Adnan, I believe you're asking about um, the CRS points for the postgraduate work permit, right? So do I need to have an LMIA job offer to get the additional points for the job offer for Express Entry? And the question is, yes. So um, in most cases, you will need to get LMIA to take advantage of those additional 50 points, right? Adnan, you also need to look into what's called the transferability points. In other words, the combination, because when you get close to 2 years of Canadian work experience, this is when you're going to get to start to get a lot of additional points for your postgraduate work permit. So the 1 year mark you get 40 points, the 2 year mark you get a lot of transferability points, which can give you anywhere between a 40 to 50 to 60 additional points depending on your language score, your education, and whatnot. So let's focus on your question here. Let's talk. So here's the page that talks about LMIA exempt job offers. So in your case, you have an open work permit, right? The postgraduate work permit, and you have a job offer. The question is can I get additional points if I have a job offer without an LMIA and I'm a postgraduate work permit? So there we go. So as I talked about, most cases your employer needs an LMIA. Some jobs do not need an LMIA. All right. Well, let's look at the jobs where your employer does not need an LMIA. Well, the first condition is that you are working full time for the employer on your work permit. And this is where it's going to fail for postgraduate work permit holders. The postgraduation work permit holder is an open work permit. Right? So if it's an open work permit, your employer is not going to be on your work permit. If, for example, you're LMIA exempt, mobilité francophone, you're MIA exempt coming from the States, and you have a named work permit, right? And your employer is on your work permit, you have to work for them for at least 1 year before you can claim the points for your LMIA. The next thing is a valid job offer. Let's take a peek here. It talks about the work permit, the valid job offer, what needs to be on the work permit, and so on. So we can get a little bit technical. In short, I mean, there's no short way of putting it. There's very technical requirements. Take a look at it to see if you meet the requirements for valid job offer, and then your valid work permit has to be exempt LMIA under one of these 3 categories, right? So again, postgraduate work permits are not going to be here, right? We're talking about, as I've mentioned, international agreements, agreement between Canada and a province, or a significant benefit, mobilité francophone. So if you're postgraduate work permit holder and you need to get your employer to get an LMIA unless you meet into one of these Canadian interests LMIA exemption codes that we touched upon previously. So there we have it. So what you should be doing right now, Adnan, is speaking with your employer. So usually large employers are going to have HR departments and have experience in LMIAs. You can only get an LMIA if there's no PR or Canadian citizen that can do the work. So if you're working in a field where there's a lot of Canadians that can do it, your employer is most likely not going to request the LMIA. In some cases, the employers want to support you. They want to retain the talent. They want to avoid having to train somebody else. In those cases, they will work with you to create, to try to again, employer driven, right? They're going to work to try to get this LMIA and prove that no PR citizen, that no PR or Canadian citizen can do the work. So you can also switch employers. You can look at other employers who might be willing to offer you an LMIA, right? It's a competitive job market today, so definitely keep an eye out. But again, the 1 year mark, you get 40 additional points, and keep an eye out for the combination of points. Seems like the construction has restarted in my place here, so I do apologize for the additional noise. Abby Verma, hi sir. Please tell me, I had lodged my file for study visa in June 2nd. When will I get my results? All right, well, let's switch over here to the processing times. Let's head here to study visiting, study working. Again, we don't have much information about your country, where you're from, and whatnot. Let's go study permit from outside Canada. And here we have 12 weeks. This does not break up the regions. Some regions take much longer time. This does not also break up the different study permit programs, right? There's the global student. Sorry, I just want to find the correct name. Right, so we also have the direct student stream. This would be another application. They say that the processing times are usually between 20 days. This only applies to some specific countries. Here are the specific countries: India, Morocco, Pakistan, Peru, Philippines, right? So under the direct student stream, some countries you will get your processing time quicker, but we don't actually know the processing times for each country. So here are the requirements you have to do to meet under the direct student stream. Student direct stream. So anywhere from 20 days if you're applying under the direct student stream to anywhere from 12 weeks depending on where you're located, but unfortunately we don't actually know. Josh D, can you talk about backlog and expected dates for application outcome? Josh D, I don't know what program you're applying to. Check the calculator that I was just on, right? Check this calculator. Let's get to it. All right, check your application, right? If you're doing economic immigration, you're applying under the federal skilled workers. What is the processing time? Well, there we go, 26 months. This being said, you might qualify. This is this is quite long. Do you have another stream? Canadian experience class? 13 months. In some cases, you can apply for bridging open work permit to allow you to keep working in Canada until a decision is made on your file under the Canadian experience class. So it really depends on what you're looking for, what you're applying. The IRCC is trying to get back to normal processing times by the end of the year. This being said, they have a massive backlog of over 2 million applications. So a lot of files that are pending, but they're working very hard on this. Adnan has a follow-up question. My express entry profile is not counting points for my Canadian work experience with foreign work experience. You have to check to see whether or not it's the correct NOC codes, right? If we go back here to the ministerial instructions, I believe you're talking about the transferability points all the way at the bottom here. So there's a point, it's going to be combination, right? So you're interested in combination of Canadian work experience and foreign work experience. Well, let's go take a look. Right, oops, sorry. Combination of Canadian work experience and foreign work experience. So there's specific, so do you have, right? Do you meet these specific requirements? Are those inside your profile? And when it comes to the actual work itself, there's various, when we talk about Canadian work experience, that there's caveats to it, right? Is it in the correct NOC code, right? They're only going to count Canadian work experience in some cases. They're only going to count it if you're in a NOC, right? If we go back here, see, they're only going to count it here if it's in level A or B. So if you have a NOC C right now, does not count. It has to be full time. Is it part-time work experience? Within the last 10 years. Are you getting paid, right? So these are important factors as to whether or not it is actually Canadian work experience. Again, when you look at the website, it talks, or when you look online, people use various terms. I really encourage you to go back to the ministerial instructions to see what does Canadian work experience actually mean, right? Here are the points you're going to get. Here are the caveats. for the purposes of this section, here's what you need to meet. So we see sometimes people working in NOC for a year or two. Well, guess what? You're not going to get any points for Canadian work experience. They want people to work in skilled level occupations. Take a look at your profile, take a look at what you've answered, and if you're working in a NOC job, get into a NOC B as soon as you can. All right. Aaron says, I got a job offer from an IT company, which is not in Canada, but I have work for their client on site in Alberta. Should it be counted as Canadian work experience? All right, so if we switch back here, so we're just talking about work experience. Talked about some of the caveats, talking about the work experience, but if you keep scrolling down, we have actually other requirements as well, right? So work full time, work in excess, and the work experience requirements. So for this to be counted, for example, you need to have a temporary resident status, right, inside Canada. It has to be full-time work, right, the equivalent of 30 hours per week. And in most cases, you're only going to get the points if you did this for 1 year. So if you're not physically inside Canada, right, if you're not inside Canada with a temporary resident status during your work period, it's not going to count. There we have it. So if you're teleworking, you're working abroad, but you work for a Canadian company inside Canada, but you're doing work for a company that's inside Canada, but you're working abroad. For example, you're a national of India, you're working from India, and you're providing IT support services for a company in Canada. It's you don't have a temporary resident status during a period of work, and so it's not going to count. Francis, thank you for your response. All right, guys, we are wrapping up. Unfortunately, I do have to go. I have an appointment in 10 minutes. So thank you so much for joining us. We're going to finish on this very last question. Bhuvan Grover says, hi, is there any chance for CRS score 524 in tomorrow's draw? Fingers crossed for you. I think 524 is good. Again, I don't give any guarantees or whatnot, but I think you have a good likelihood of tomorrow, or if not tomorrow, in the following draw to receive an invitation to apply. I love to work with you to properly prepare your invitation to apply, make sure everything's accurate, and help you submit your EAPR. So please head on over to our website, Hopefully Immigration Law, speak with a lawyer, and here at the bottom you can find me, Cédric Marin, book a consultation with me, and this is how it all begins to help you with your file. Good luck to everyone on the CRS points. Again, I strongly recommend that if you can, to go on our website, if you're under the Canadian Experience class, go to our website and look at this video on the breaking news. This video right here, we talk about, we're gonna hide this. We talk about if you're Canadian Experience class with study in Canada, be sure to update your profile. We actually wrote a blog on it as well. So you need to update your profile. You need to answer some questions to maintain your CRS score. Today is actually the last day to do it before midnight UCT time. You must update your profile if you're under the Canadian Experience class. If you have Canadian studies, super important. Also, as we talked about, tomorrow we're expecting another draw. So really wishing everyone good luck with the next draw that's coming up. Again, I'm Cédric Marin, an immigration lawyer at Hopefully Immigration Law, and I'm wishing you a wonderful week. I'll see you guys next week. Thank you so much. Bye-bye.